Happy Friday. It's 6:30. I don't know what you guys are up to. I'm supposed to go have dinner with a few attorney friends later on, but we'll see. But for right now, I just wanted to do a half-hour session, maybe do a little shorter, depending on what people want to do. People ask how involved we get. If you want to go ahead and ask your questions now, that way I can start thinking about them. Cheers. Cheers. That way I can start not looking up the answer. Most of the time I know the answer, but in some cases it might be too complicated. So I'll have to dig into my brain a little further to shake it up and see what I saved in there. Juanita, I think you're from LA, are you not? If I recall correctly, you're from the LA area. Is that true? Any event, I'm recording this, so this will be loaded onto the YouTube channel that I have going on. Law firm marketing services join. All right, we've got a law firm marketing services, San Diego. Okay, so you're from down south. As you may or may not know, there exists a confidentiality between attorney and client. If you were to come to my office and consult with me, our conversation would be strictly confidential. There's nobody who would be able to pry that information out of my brain. Whatever you tell me is 100% confidential. Obviously, in this setting, confidentiality is thrown out the window. So do not disclose anything that is confidential on here. Do not ask me anything through the messenger, or obviously you're not joining me live. So, you are here while I'm on live, but I'm not sharing the screen with you so that you're not being seen by everybody else. So your question's not going to be heard through audio. It would be strictly through the messages there. And I think people can see it. So I definitely don't want you guys asking any questions that are going to be prejudicial to your case, because you never know who can get some information, and it could be very damaging. So you definitely want to make sure that if you have a confidential question, you guys message me on my email, which is wilbur@salgadolawoffice.com. Best thing to do is to make an appointment. Come see me at the office. We could also do a Zoom consult, or we could do something through the telephone. Again, that's the first thing. Confidentiality is very important. The second thing is the attorney-client relationship. Obviously, I am not your attorney. No one here that I know of has hired me to be your attorney. If someone comes on here later on and is my client, then obviously that's going to be very different. Oh, Elise, how are you? It's nice that you joined us. I knew you would join. I'm talking about the attorney-client relationship. Obviously, I'm not your personal attorney. If I am, and you're on here, then we have a contract or an agreement that we both signed that I'm doing services for you. This is just general advice I'm giving out to the people, because I like doing this kind of stuff, going on live and interacting with people. So what's up, Casey? Derek, we're going to meet up later on. Save me a seat. What are you guys doing? Are you guys at the restaurant right now? I told you I couldn't make it, but I'll be there in a little bit. But I got my wine. Cheers. I'm going to wait a few more minutes. Maybe one or two. But again, the topic tonight is child custody and visitation. There's no client-attorney relationship at this point, because unless, again, you've hired me already, because I'm just giving general advice. So please, if you need the services of an attorney, come see my office, or come see any attorney that is experienced, and then retain him, go through the proper channels in order to have that attorney-client relationship. Right now, I'm just giving general advice, and take this with some caution, because I don't know the entire facts of your case. If you ask me something later on and I give you some advice that may not be applicable to your case, for whatever reason, sometimes you've left an important detail that I should have known. But because we're not in the setting where I can really extract information from you, it's best that you consult with an attorney if you're really serious about hiring an attorney. Again, this is general advice. Probably you might as well just Google your question. But hey, at least you have a live person here who can hopefully answer your questions. But let's get started. I don't want to wait too much longer for those people who have been signed on early on. Thank you, everybody. Again, this is Attorney Wilbur Salgado. I practice out of Modesto, which is Stanislaus, Stockton, San Joaquin County, and Merced, which is County of Merced. I am an attorney I've been an attorney for 7 years. I practice criminal defense and I practice family law along with bankruptcy. Family law has different branches to it, as you may or may not know. Family law includes divorces, child custody, child support, spousal support, division of the community property, just all a hot mess of things that can happen in family law. And we could even go into a subset of family law or a whole different branch altogether. I guess it would be child dependency, which is when CPS is involved. It's one of the questions that someone asked earlier on in one of the stories where I allowed people to ask questions what they wanted to discuss tonight. So when you have children with somebody and you've split up, let's say you're a boyfriend, girlfriend, or you weren't boyfriend, girlfriend, you consummated a child, and here you are, you've got this child, but you're not seeing the child, or there's issues with respect to how it is that you're going to go about and have visitation with this child. You would go to your local county and file a petition of some sort. If you're married, you file a petition for divorce or whatever grounds you want to ask, if you want an annulment or for irreconcilable or not irreconcilable for fraud or another basis for it. That's a whole different topic. But you'd file a petition, and then you also do what's called a request for order for a child custody and visitation order. The other petition, if you're not married, is the petition to establish parental relationship. It's a different set of documents. You can get these documents online. You can just go to the court's website and they have the packets. Before COVID, a lot of people would just go to the courthouse and pay purchase the packet. I think it was like $5, and then it had instructions. But now I think you could just download them. And there's also the self-help center where you can actually go to the self-help, and they would, back before COVID, they would help you fill out the forms. There was actually an attorney there who would help you fill out the forms, but not anymore. I think now they're still open, but you have to submit the paperwork by email, and then they'll give you feedback as to what you need to correct, which makes it very difficult. All right, so that's how you get started. You file a petition. Once you file the petition and you file a request for order for child custody and visitation, you got to put the reasons of why, what you're asking from the judge. So many people I've seen, when they're representing themselves, they're not very specific. They don't address the concerns as to what kind of visitation they they want from their child with their children, what they want from the other parent. Hello, Liz. Hey, Liz, how are you? I told you I was going to do it. So here I am. So you want to be specific as to what you want. What kind of parenting plan do you want? Don't just say, I want more time with my children. Well, what does that look like? Do you want Friday to Sunday? Do you want Wednesday to Sunday? Do you just want overnights from Monday to Tuesday? The judges and the mediators, which I'm about to go into in a little bit, they're not mind readers. The attorneys aren't mind readers. You got to let us know what you want, what works around your schedule, what works around your lifestyle. If you're working graveyards, obviously your visitation schedule is going to be different from someone who works day shifts. If you're working on weekends, you're obviously not going to have weekend visitation, although you may, but in some circumstances you won't, because it's better fit for the child to be with the other parent who may not be working. So those are the things you got to consider. Okay, in California, every case has to go to mediation that is concerning child custody and visitation. You have to go to mediation before you ever see the judge. Now, what does that mean? It means exactly what I just said. You go before a mediator. So your attorney, if you hired an attorney, and if you have another person, which you should, with the baby daddy or your ex-husband or whatever, he's going to be there with an attorney if you hire an attorney. But if you didn't hire attorneys, then you're both there together, and you're going to go in a room with a mediator. Well, I'm talking pre-COVID now, but we're going to get back to that eventually. I think maybe, I don't know. We should anyways. You'll go into a room or a conference room with a mediator, and you'll both on a day, and it's usually in the mornings whenever they schedule these mediation hearings, you'll go in and discuss some sort of plan, some parenting plan that is beneficial to the child, because that's the law is that the mediators want to formulate or create a child custody and visitation order that is in the best interest of the children. Okay, not what your dream and aspirations are or what his dreams or aspirations are. They want to know what's in the best interest of the child, with the underlying basis that knowing that it's in the best interest for the child, also that he or she have continuing and frequent contacts with both mom and dad. So that's the mindset that you're supposed to go into, or the mediator is supposed to go in there, and the parents are supposed to go in there thinking as they draft up this plan. The mediator usually will ask you questions about your work schedule, again, your lifestyle, where the child will sleep, the siblings, who lives in the house, etc. You delve maybe into your criminal background if there's some concerns there. Both parties will be asked the same question, and then they'll try to create a schedule. Most of the time, people do come to an agreement with the mediator, okay? And then the mediator will then draft up a recommendation, and this recommendation goes before the judge. At that point, it would become an order because you're in agreement, so it's really a stipulation at that point. And the stipulation is a legal agreement between two parties that will eventually become the order of the court. So then that is given to the judge. The judge signs off, stamps it, and you have your child custody and visitation. Congratulations. You guys were successful in creating a child custody and visitation order that fits both of you without having to go and litigate before the judge. And that's very good. It's healthy for the children. It's always best to try to work things out outside of court if possible, if not in mediation. Because then once you give it to the judge, it's out of both your guys' hands. You really have no bargaining power. No, it shouldn't be a power thing, but you have no leverage at that point, because during mediation, you could still negotiate back and forth. You can counteroffer, you can give and take a little bit, but when the case is before the judge, it's really going to be up to him. So having said that, if you don't come to an agreement with the mediator, then it depends on what type of county you're in. There's 58 counties in Stanislaus, or 58 counties in California, the last time I checked. And each county, like I said, you have to go to mediation. All of the counties, you have to go to mediation before you ever see a judge when you're trying to get child custody and visitation orders. But if you live in a recommending counseling, if you don't come to an agreement, the mediator is going to recommend what type of visitation schedule you guys should have. And the judge, most of the time, will implement that schedule. Because, of course, these mediators are educated, they're licensed, and they're not just some dummy off the street. They didn't get Pablo from down at the taco truck to come down and help you out. They hired people that are educated with training, extensive training, to try to help you out. So having said that, the judges defer to the mediator's recommendation, and that usually will become the order of the court. You can challenge that, which I'll talk about that in a little bit later on. But if it's a recommending it's a recommending county, then whatever the mediator recommends will normally become the order of the court. If it's not a recommending county, then the mediator just walks out, and then basically you will have your turn to go before the judge and argue whether what's in the best interest of the child at that point. And that's when you should really have an attorney, because that's when things get a little complicated and tricky at times, and you don't know your rights, which leads me to what I just said earlier. You have a right to always contest the mediator's recommendation. And so you do that by asking for an evidentiary hearing or a contested hearing. Some counties call it long cause hearings. Some counties call it trials. So the verbiage is a little different, and even some attorneys I've been in counties where they labeled it something else. And I'm thinking, wait a minute, I want an evidentiary hearing, or I want a long cause, and they're looking at me like, well, that's the same thing. And I'm thinking, well, I didn't know that. I'm new to this county, but so. You do have a right to contest it, and then they'll give you a day to come back way down the months, depending on how the calendar is, especially right now with COVID. They're really backlogged. So you're looking at going to trial maybe within 3 months to a year. So it's best to always try to work things out if you can. Always talk to an attorney before. If you can't afford one, at least consult with one so you get an idea of what type of county, how the procedures are. For example, things change from a month-to-month basis. Now with COVID-19, the mediations are by telephone. And so you file the paperwork I discussed earlier, the petition, the request for order, and there's other documents that you also definitely prepare with that, okay? And so you have to serve these documents. I'm not even going to go into that right now. I'm just talking in general terms, because if we go into service, it's going to complicate things. That's a whole other session in and of itself. But going back to what I said, I lost my train of thought just thinking about service. So it's always best. Oh yes, how they're handling things in Stanislaus County. Well, once you file your paperwork, you'll get your court date or the mediation date, and they'll also eventually mail you a call-in number with a code, because they're doing the Zoom telephone now. So you're going to be going into mediation by telephone, and that gets a little bit more complicated because evidence. How are you going to present evidence if you're over the phone? So you got to be able to figure out who do I send the evidence to. In Stanislaus County, there's an email you send your evidence to. You have to scan it, upload it, and send it through email. Okay, anything you want the mediator to review in assessing or determining a parenting plan, you have to email it. And so you got to be up to date on that information. So it's good to talk to an attorney. If not, try to call the courthouse clerk and find out information. Although again, hours may be limited because of COVID, so it's important that you call ahead of time and you're not waiting the week before your hearing. If you're waiting before the week before your hearing to get ready, something's gone wrong, because you probably haven't even served the other party and your case is going to get thrown out. So at that point, go talk to an attorney, because your options are very limited at that point, and maybe they could what's called reissue the request for order and get you a new date. Okay, so I'm going to talk about the legal types, or the different types of custody. A lot of people get tripped up and they get emotional and upset because they don't know the difference sometimes. So they hear this term and they go, I wanted sole custody. Well, sole custody doesn't exist. What you're looking at is sole legal custody and sole physical custody. Those are the types of custodies there are. And there's also joint legal custody and joint physical custody. When we're talking about custody that is legal, or legal custody, we're talking about the type of custody that gives the parent the right to the legal decision making. Where is this kid going to go to school? What doctor is he going to see? Is he going to receive mental health treatment? What extracurricular sports activities is he going to be enrolled in? Or religious affairs? What type of religion is he going to be involved in? If you have legal custody, you have a right to have an input on that decision. Most custody orders, except if you're, a real bad mom or dad, allow both parents to have joint legal custody. Okay, that way they can both make decisions about the child's welfare. Now, if they don't, if one only has sole legal custody, if one parent has sole legal custody, then that means that only that parent makes the decisions. Okay, and then the other type of custody is physical custody. Physical custody is more. It makes more sense because it's whoever has the child, so to speak. So the person who has sole physical custody is the person who primarily has a child who lives with, or the child with whom the child lives with most. So is this going to, hold on, Jesse, is this live going to stay on your page? Great information, but I'm going to upload it onto YouTube and put it on my page eventually. So yeah, it's going to be up there. I was doing videos before on YouTube, but it was cumbersome and I just never got around to it. And now I'm forcing myself to do this on Friday nights, which after a long week, I really, it's nice to see all y'all, but I want to help you out too. But I want to drink. It relieves some stress. Anyhow, so going back to the physical custody, if you have joint physical custody, it means both parents have almost an equal timeshare, meaning that they both share the child. The child's at one parent's house maybe 1 week and the other parent's house 1 week. So they have physical custody of this child. It's very rare for parents to have joint physical custody. In my experience, usually one parent has sole physical custody or primary physical custody, and the other parent has what's called visitation. If you have visitation, that doesn't mean that you don't have rights. I've had parents get upset at me and say, wait a minute, all I have is visitation. No, it's all right. That means that you're allowed to see your kid. If you have a 50-50 timeshare, you have visitation. It's 50% timeshare. So don't freak out if you hear that word, well, you're getting visitation. Well, that's good. That's what you want. You want to be able to see your child. That doesn't mean that a lot of people, I think, believe that it's got that connotation that visitation is only like weekends or maybe supervised. If you're having supervised visits, something's gone terribly wrong in your case, and there's some issues you need to resolve. So basically, that's kind of the quick, fast, and dirty spin on custody and visitation. We got about 10 minutes left, so I wanted to answer some questions from the audience if you have anything. So go. This is your time, folks. Anybody want to ask anything? If you have any legal questions, I know some of you have it. I heard there's an advantage to being the first one to file. No, that's not true. It depends. It is and it isn't. Okay, it is and it isn't. If you have facts about the other parent that would warrant a change in visitation or help you establish a dominant, I want to say, I don't want to say dominant, but help you have an advantage in obtaining more visitation time or a shift in custody or allowing you to have sole legal or physical custody, then you want to file as soon as possible, because the more time you wait, for example, let's say you find out that the father was involved in some criminal activity. Let's say that you have how can I say this? You find out that the parent has been involved in criminal activity that jeopardizes the child's safety. And this happened maybe when the child was there. If you let time pass and you don't file paperwork, then the court's going to look at you really bad when you file paperwork a year down the road and allege that, you know, the other parent was involved in criminal activity a year ago because you allowed a year to go by before you did anything. So you definitely want to move on certain facts quickly. But if it's just a general, you know, you're trying to establish visitation, you're both great parents, there was really no benefit to one parent filing first over the other. Where can you see me? Kane, goes. You know where to see me, bro. You got my number. You've got my cell phone number. It's a high school friend. He's being a little punk. Get out of here. Let someone else answer a good question. If one parent has sole physical custody, when no visitation, can the child change their last name? No, the standard for changing the last name, I believe, is the same as child custody and visitation, but it's a little different. The older the child is, the more difficult to change the last name. I have to look at the code and the case law on it, but just because you have sole physical and sole legal custody over a child is not an automatic guarantee that the child's name will be changed, although it does help you out, especially if the father hasn't been around for a while. It does help. Any other questions? When can I see you? Kane, just give me a call after 7. Okay, give me a call after 7 when I get off. Let me see what else we got here. Why did I become an attorney? Because someone told me that I would make a lot of money. No, I'm just playing. I became an attorney because, I don't know, someone told me that I'd be really good at it. I thought that there's a lot of people that need help and don't know really how to represent themselves. So I went into it thinking I'd be like the people's champion, so to speak. I know it's cliche and idealistic, but it's the truth. And now I drink on weekends. Anyhow, let's move forward. I know someone asked me how was law school. It was very difficult. I lost 4 years of my life, but I gained independence. Someone asked me also on Messenger, what is an ex parte application and how can that help you in the context of family law, not the context of civil law. This is completely different now. In the context of family law, an ex parte is usually used in two ways. An ex parte means that you've talked to the judge directly without the other person being involved or the other party, and that's usually not advisable. You could actually be sanctioned for that. But in the other term, it's used in the sense when you are actually applying for an emergency order with the judge directly without the other party being a participant in the case. So let's say, for example, I talked about earlier, the other parent's been involved in some criminal activity. You want to file a document for custody and visitation or a change in custody and visitation. You want to do that on an emergency basis. So you file what's called ex parte paperwork to directly send that to the judge so he sees that paperwork right away. And because you obviously want to protect your child and will act on an emergency basis. And that's when the ex parte basis is used. So it's very beneficial. You still have to give notice in some circumstances. You have to call the other person and say, hey, I'm going to be filing emergency paperwork with the judge tomorrow. And, you know, so that gives them an opportunity to file their counter response. Most people don't do that because most facts allow you to file paperwork And well, in my cases, most facts have allowed me to file paperwork without notifying the other person. So the judge sees the facts as they are and issues temporary emergency orders. In the meantime, pending the hearing, they usually schedule the hearing about 21 days out or less in order to allow the parties to go into court. And when I say parties, I mean, I'm not talking about LMFAO parties. I'm talking about the partners, husband and wife, or mom, dad, or in this case, we can have, moms. So it's 2021 now, folks. Someone had asked me if you could have a restraining order dismissed. Yes, you can. I advise you not to do it on your own. You should definitely talk to an attorney to get a restraining order dismissed. The code section, it's not in my head. I have to look this up because I don't just sit here and record code sections in my head. But there's a code section that allows you to have a restraining order dismissed when there has been a change in circumstances that led to the original granting of the order, or where it's in the best interest of justice. There's a case law on that. Case law are the cases that have come down, or decisions that have been come down from the appellate courts as to how the courts are applying that law in order to dismiss the cases. So it gets a little tricky. You definitely want an attorney to help you out with that. Casey, are you still there? You're coming in and out, huh? You're waiting for me to go meet you guys at the restaurant. All right, guys. So you guys I got like 4 more minutes. You have legal questions about your child custody and visitation stuff, ask me now, because I'm going to go have a drink with my friends. I'm going to be doing this every Friday at 6:30. Obviously, some Fridays I won't be able to do it because I'll be taking off somewhere. You guys know I'm always taking trips. But for the most part, I'm going to be doing these videos, and then I'm going to upload them into YouTube. I have what's called the Dr. Divorce series. I have my own YouTube channel. I started it earlier this year during the pandemic, and then I didn't get really involved in it because I got busy with work, I guess. But now I really want to get into it. And with doing these Friday videos, I think it's going to really help out. It's going to help out a lot of people get some information. So if anybody doesn't have any other questions, I'm going to let you guys go in about a minute. It was really fun. I think 30 minutes is perfect for a little tidbit of legal information. And then I got to answer some questions. But if you guys want to come see me in person or through Zoom or by telephone, give me a call, 209-300-7825. We will gladly set up an appointment with you so that we can discuss your case. Again, this is not create an attorney-client relationship. If you want that, you have to come and sign a fee agreement or an attorney-client agreement, some sort of agreement that I'm representing you. I hardly do pro bono cases, although I do sometimes do them. Most of my cases, I do have to charge attorney's fees because I have to pay my staff and I have to be able to afford my wine. So, okay, guys, but I am located in Modesto. I am Will Salgado. I am the Dr. Divorce on YouTube, and I practice in Stanislaus, Merced, and San Joaquin counties, which is Modesto, Merced, and Stockton. I may be practicing in other areas as I get more cases, as I explore more of the Zoom hearings because of COVID. It's the novelty now is that we're able to go to court by video and telephone, and I discussed that earlier. I will be uploading this video onto the Instagram. What is it? What is the one where you're able to upload longer videos? I can't remember. Insta TV or something like that. It just shows you how much I know. But anyhow, it'll be on YouTube. I'll put this up. I'll post a snippet of this later on in the regular page. All right, guys, have a good weekend. Keep up the good fight. Stay safe during COVID-19 and stay out of trouble. And don't have babies with people you don't want to have babies with. Bye-bye.